So thank you all for listening and welcome to this presentation about my dissertation project, which is currently entitled The Influence of Ordoliberalism on the Development of European Competition Law as Mirrored in European Commission Publications. And in the first part of my presentation, I will briefly present my project in its entirety so that you have the necessary context. And then, since today's conference aims to discuss how to capture Europe in digital sources, the second part of my presentation will focus on the legal database that I have constructed as part of this project, and that includes all competition decisions of the Commission. In particular, I will describe the technical advantages and problems associated with collecting these decisions. I will provide some descriptive statistics and finally point towards further research questions. So let me start with the historic existence of different economic schools of thought that have reflected on competition and competition analysis. And this this classification is quite established in the literature. It ranges from the Harvard School to the Austrian School to the Freiburg School's ordoliberalism, and includes various versions of the so-called Chicago School. What is less clear, however, is these schools' actual relevance on European policy over the long run. And I quote from one group of competition law researchers in 2011 who wrote, quote, "Much uncertainty and even confusion still remains over the precise ideological content of the economic doctrines used to build, legitimate, and implement the EU's competition policy throughout the whole of its history." And my dissertation project aims to address this gap by providing a long-term quantitative analysis of European competition policy as conducted by the Commission. The goal is to clarify the influence of different economic doctrines by introducing previously unconsidered source material and an innovative methodology into the debate. Why is any of this important? Analyzing to which extent different economic doctrines influence European competition policy promises to contribute to three important academic discourses: one dealing with the past, one dealing with the present, and one dealing with the future. For reasons of time and because we are participants of a conference on EU history, I will confine myself to the historical discourse. Within this historical debate on European competition law's past, Gerber has argued in a well-known book that key German players such as Walter Hallstein, Hans von der Krügen, and Alfred Müller-Amack successfully injected ordoliberal, that is, German ideas into the DNA of European competition policy, most importantly in the form of Articles 101 and 102 TFEU. Over time, his argument has been supported by a stream of articles which associated several aspects of EU competition policy with ordoliberalism. For instance, scholars identified the ordoliberal school in the legal consideration of broader socioeconomic goals, in the protection of small and medium-sized enterprises, in the balance between competition infringement and property rights, in the use of the ordoliberal as-if principle, and in the subordinate role of consumer welfare in merger control. However, this link between the ordoliberal school and EU competition law is still controversial. To begin with, many historians simply believe that European competition law is an imitation of US antitrust law. And recent literature argues that there is little archival evidence of an ordoliberal legacy, but a growing influence of the Chicago School. So far, this debate has not been solved. By shifting the focus from the alleged influence of ordoliberalism on the genesis of EU competition law to an examination of the actual relevance and dissemination of ordoliberal concepts, my thesis aims to provide a re-evaluation of this debate in the literature. And to contribute to this clarification, I am currently constructing or have constructed 4 central databases that allow for the application of text mining methods from the field of the digital humanities. First, all 957 articles published in the Freiburg School's favorite journal called Ordo were downloaded and converted into a machine-readable format. So that's again the OCR issue. And every article was also supplemented with relevant metadata such as author and year of publication. Exploring this database both qualitatively and quantitatively has allowed me in the first part of my thesis to describe the ordoliberal understanding of EU competition policy in great detail, and it helps me to analyze how this understanding has evolved over time. The second database that will be presented in more detail in the second part of my presentation captures the Commission's competition decisions. And again, I can include further metadata on the respective cases. For instance, there are information in the so-called reports of Commission decisions relating to competition, which are available online from 1973 onwards. And the Directorate General for Competition, or short DG Comp, has developed an own case search tool, which is also available online and includes all cases that have been appealed to the court. A third database covers what I call soft law publications of the Commission that are relevant for EU competition policy. For example, the Commission's annual report on competition policy is available from 1970 onwards, and it summarizes detailed information on the main initiatives and decisions over the past year. And it thereby indicates what the Commission considered to be relevant ideas and cases in a given year. Moreover, as you can see on the slide, there are also speeches, press releases, newsletters, and articles that are available online. And for the historical narrative, in my thesis, I complement all three databases with contextual biographical information on key employees. These information can be obtained from the official directory of the European Union from 1980 onwards, historic organigrams that are available for the whole period, the EU Who is Who website, and of course by archival research. To evaluate the wealth of semantic data stored in those four databases, several text mining techniques can be used. These techniques are based on the assumption that the frequency of certain words and their concurrence in a database are reliable indicators of the subliminal themes, feelings, and discourses. Using these databases, we can answer questions as the following ones. Is there evidence of an ordoliberal influence in the Commission's publications? And if so, what words, concepts, and cases are involved? How does this influence change in relation to external factors, such as macroeconomic data, the level of development of the EU, or the commissioner responsible for competition policy? Or which publications, cases, and words stand out in a statistical sense, and which overall narrative regarding the history of EU competition law can be derived from them? To successfully capture Europe in digital sources, this approach requires that the content of these sources can be coherently digitalized and meaningfully quantified. Digital representation of text has several characteristics, such as dramatically reduced transaction costs that distinguish it from more traditional sources. Importantly, the data structure of the underlying information allows machines to read through vast amounts of text very quickly in a process that has been described as distant reading. Moreover, publications can also be related to metadata. For instance, speeches can be tagged to indicate the name of the speaker, the title, the general topic, location, and date. This tagging allows to analyze predetermined types of data while simultaneously mining the text for additional characteristics such as text length or word selection. By complementing the work of close reading undertaken by previous researchers, this approach enables analyzing the Commission publications in a way that facilitates the identification of large-scale patterns and crucial outliers. Compared to conventional legal historical studies, this results, hopefully, in a more precise and consistent consideration of the dynamic dimension between actors and legal sources. By utilizing text binding techniques, one can compare the language of a given school of economic thought with the semantic features of the Commission's competition decisions. And this makes it possible, ultimately, to empirically examine narratives of change in competition policy. In the remaining minutes of my presentation, I would like to focus on the legal database containing all the Commission's competition decisions. While public datasets with pre-coded information can be extremely valuable for conducting research, they are so far relatively scarce in the field of European law, especially compared to the US. However, scholars have recently started to assemble their own specialized datasets on European competition law in order to conduct quantitative studies, and my PhD project is part of this broader trend. For instance, Carré et al. Provide a survey of European antitrust law enforcement since its foundation in the Treaty of Rome of 1957 up to and including 2004. They present a complete overview and statistical analysis of all 538 formal Commission decisions under the relevant articles of the European Community Treaty. However, their dataset neither includes European merger and state aid decisions, which are several thousands each, nor decisions under the earlier European coal and steel communities. All competition law datasets that I am familiar with, and especially the ones that are publicly available, lack the full textual content of the decisions. This clashes with my goal to conduct different text mining exercises in order to investigate the semantic role of different schools of economic thought. Due to the scarcity of suitable pre-existing datasets, I decided to manually collect data specifically for the purpose of my study. In particular, I turned to the EUR Lex website, which hosts the official journal of the European Union, Series L and C. It is, as such, the original source of any and all EU legislation, including regulations, directives, decisions, case law, and treaties. The website publishes new documents and legal acts up to several times a day, and it connects them with relevant standardized metadata, which is quite helpful for researchers because you already get a first sense of how to classify these sources. To construct my own EU competition law decision database, I applied the following search criteria. And you can see that on the slide. The domain was restricted to EU law and case law. The subdomain specified as legal acts. The form given as decision. Directory code level was competition policy. And of course, the author had to be the European Commission, because I'm interested in Commission publications. And my search language was English. At the time of constructing my database, using these criteria yielded 8,635 acts. At the most basic level, this dataset can now be used to look at different competition policy trends. For instance, I brought you this slide on which I plot all decisions over time. And this shows that there's a sharp increase in decisions from the 1990s onwards. This illustrates quite nicely why the Commission tried in 2003 to reduce the bureaucratic burden associated with competition law decisions by putting an end to the previous notification system, under which companies notified agreements to the Commission for approval, and then the Commission had to approve them in a formal decision. Since I would like to demonstrate the influence of different schools of thought on European competition policy, mainly on a semantic level, that is in terms of words, phrases, or certain arguments, it is important to consider not only the quantity of decisions, but also the length and the amount of words captured in each decision. So on this slide, I aggregate the number of words in all decisions for a given year. And indeed, there are certain differences in comparison with the previous figure, even if the general upward trend remains more or less the same. And these differences are not surprising, as the content of a decision can be very different. For example, a purely formal approval of a planned merger between two companies is often only 2 pages long and relies on standard language that is employed in most of the cases. In contrast, there are also decisions on the, for instance, exploitation of a dominant market position. And these are much more complex and much more lengthy, because first you have to define the relevant market in detail, then you have to describe and investigate the conduct to be condemned. These kinds of decisions can therefore include several hundred pages, and they have an enormous influence on the word count trend as shown on this slide. To get a first overview of the cases in terms of content, one can also check their respective classification. And as I mentioned, these can be obtained by also mining the directory code level 2 on the EUR-LEX website. And I extract that together with text, title, and date of the respective decision. The results are shown on this slide. Overall, most cases are related to merger control, as shown in the top left panel under the heading Concentrations. The 3 other pillars of competition law, restrictive practices, dominant positions, and state aid, make up most of the remaining cases. While I am quite happy with my database so far, I also want to note a few problems. As I mentioned earlier, the EUR-LEX website includes all decisions that have been published. However, under the previous competition regime that was valid until 2003, for instance, more than 90% of cases were closed informally by sending so-called comfort letters, which were only rarely published in the official journal, thereby limiting the system's transparency. So I conducted a robustness check on my data by searching DG Comp's list of older competition cases between 1964 and 98. And I discovered that this list features numerous unpublished decisions, which usually concern either rejections of a complaint or exemption decisions. This means the Commission decision database as obtained via the EUR-LEX website is not complete, but it contains all published decisions and therefore arguably the most important ones, I would say. Moreover, the website provides these decisions depending on their year of publication, either as PDF file or as HTML, but also sometimes in different formats. There is no single format that is available for all the decisions throughout the period, which made information retrieval very burdensome, and it means there might be some occasional spelling errors, particularly when PDFs had to be converted via OCR into text files. And as I have learned today, I have, of course, to check the OCR accuracy and the quality by conducting maybe a case study on this. So by way of conclusion, I would like to give a very brief outlook on the project. So far, I have used specific text mining methods such as topic modeling to identify characteristic words and characteristic topics in ordoliberal writings. Moreover, a similar procedure has been used to investigate other competition schools, such as the Chicago School. While this analysis has formed the first part of my dissertation, the second part, to which I'm turning in the coming months, will compare these various semantic features with the competition law publications of the Commission. Most importantly, the Commission decisions that I have presented to you today. By comparing the semantic features of the legal database with the semantic markers that I identified for different schools of thought, I hope to clarify the intellectual drivers behind the application of competition law in a historical perspective. And this brings me not only to the end of my presentation, but also to the end of my time. So thank you very much for your attention.